Welcome, everyone. We still have some folks filtering in right now, but we want to be very cognizant of your time and make sure that we can get you all the information as quickly and timely as possible. So thank you so much for joining us today. You are here for a Michigan Earned Sick Time Wage and Law webinar presented by Rehmann and hosted by the Northern Michigan Chamber Alliance. I'm Nikki Devitt, and I'm the president and CEO of the Petoskey Regional Chamber of Commerce, and I serve as chair for the Northern Michigan Chamber Alliance. The Northern Michigan Chamber Alliance is a coalition of 19 chambers and economic development agencies from across Northern Michigan and the Upper Peninsula, and we advocate for rural Northern Michigan businesses. The Alliance was formed under the premise that many legislative issues, like the ones we're going to talk about today, impact our region differently than they do the rest of the state, and we need a collective voice for our regional businesses. So understanding that, we know the critical importance of today's webinar to better understand the Michigan Earned Sick Time Act and the impacts that could likely take effect on February 21st. More importantly, how does it impact you and your business in our Northern Michigan and Upper Peninsula region? So we have a lot of information to cover. We understand that you're going to have questions, and a great deal of what you have questions on right now may actually come to clarification throughout the webinar. If you have questions, please use the Q&A box, not the chat, the Q&A box, and put your question in there along with your email address. We will probably not be able to get to all questions. And what we will do, though, is make sure that we share your question and information with Rehmann and their experts so that we can get back to you and hopefully address your question if it was not answered within the webinar. This webinar is also recorded and will be sent out to you within 24 hours and will be shared on our social medias throughout our region. So not just the Northern Michigan Chamber Alliance, but all our participating chambers and economic development organizations. So with that, I would like to now turn it over to Laura Oblinger, who is Director of Client Services and Business Development for Rehmann.
Thank you so much, Nikki. So what I get the opportunity to do is really tee up the specialist that's going to be talking to you today and introduce Elizabeth Williams. So if you don't know Rehmann is a full service business advisory firm. So we help our clients on every aspect of the operations of a business, and that includes HR solutions. You have in front of you today Elizabeth Williams, who is a principal with Rehmann, but more than a principal, she is one of our leading strategists when it comes to HR solutions. She is a critical component to our clients and guiding them, and her team guiding them through HR solutions. She has more than 24 years of experience and a lot of breadth and depth in this industry of HR. She has studied as best she can the intricacies of this upcoming legislation, and you are in great hands to learn a little bit more about what's ahead of us. So at this point, I would like to turn it over to Elizabeth Williams.
Thank you, Laura. I appreciate it. And welcome everyone on the call. I'm going to share my screen and we will begin. Now, please feel free to ask your questions, but hopefully when we go through this, many of them will be answered as we go. But of course, there's always how does this apply to me? So we're happy to follow up separately. Our agenda for today is really about creating a roadmap for compliance for you. We're going to talk about what the current ESTA law and LEO says. LEO is the Department of Labor and Economic Opportunity Department. When you see that LEO, that's what that means. And we're going to share some common questions that other employers have had just to cover our bases for a foundation. And then we're going to compare the House and the Senate bills that have been proposed. And finally, how employers can best prepare. So we're going to start off by talking about what the current ESTA interpretation is. And then we're going to layer in the House and Senate so you have the full explanation of it. So let's start with what we have now. Right now, Michigan, we follow the PMLA, which is the Paid Medical Leave Act, and we're going to compare that to how ESTA has expanded that. Let's just talk about the law of the land right now, PMLA. It covers employers have to comply with offering paid medical leave if you have 50 or more employees. And it basically is for your non-exempt employees who work 25 hours or more. There's also some nuances and exceptions under that law. The accrual is 1 hour of sick time for every 35 hours worked. And there's a 1 hour earned per week cap, meaning that they basically, if they work 40 hours, they're really only capped at earning 1 hour for that week. And it can be capped at 40 hours per year, and there's a carryover cap of 40 hours per year and paid all 40 hours. Now let's see how that has been stretched in new dimensions with ESTA. Covered employers, it's all employers except federal government, but only Michigan employees. So if you're multi-state, we'll get into those nuances. It really is only for the employees who live in Michigan. And it means one employee or more. So you can see the big difference. Covered employees, any person who is engaged and with servicing an employer. And we'll go through those nuances. You know, there's many different definitions of what a worker is. And the accrual has been sped up 1 hour for every 30 hours a week, and there's no cap. The use of it can be capped at 72 hours per year. And what is a year? Well, there is some flexibility for the employer to determine what that 12-month period is. Do you want to do it a calendar year, January 1st to December 31st, or July 1st through June 30th? They do give you that flexibility. The carryover currently, as ESTA has been written, is unlimited. Any and all unused time can carry over. And for paid, large employers, they do give 2 buckets to break this down. Large employers, which means to them 10 or more employees, would get the full 72 hours paid. Small businesses, they deem under 10, and they would get the same equivalent time off. However, they say 40 hours would be paid and 32 hours unpaid. And so what is this? What is the definition here of employees? It can be full-time, part-time, temp workers, seasonal, and they also count those who work at staffing agencies. So there's those nuances. Other features under ESTA is the waiting period. While the accrual is to begin immediately on February 21st, employers may require a 90-day waiting period prior to usage. Particularly, this is for new hires. So you hire someone on March 1st, they begin accruing their sick time, but you can have them wait 3 months before you would actually let them use that time. The current legislation shows that front loading, the statute is silent. Leo's position is that front loading is permissible, but employers should do a check and balance annually. Are the hours accrued balancing to what they worked, and then any carryover balance? You need to provide notice, as well as the employee needs to provide notice. If there's a need for leave and it is foreseeable, employers may require a 7-day notice. But as you know, sometimes people get sick out of the blue, or something, there's an emergency that happens, a health emergency that's unforeseeable. So the best that we can say is require as soon as practical. Use increments. Smaller than 1 hour increments, or the smallest increment used by your payroll system. And for many, it's 0.25 of an hour, right? So you can see the administrative burden. As we walk through this, keep in mind, this is why the House and Senate bills have been introduced, to clarify many of these things that are silent, and also to help remedy the administrative burden that this has. So I want you to keep this is like the foundation, and then we're going to build upon it. So we'll come back to that increment usage, for instance. The private right of action. This, under ESTA, says that employees may file claims with Leo directly or in court. So that litigious nature, there's concern there. Anti-retaliation. There is a presumption that if the employer takes any adverse personnel action, a disciplinary action, that it could be considered anti-retaliation, taking away an employer's rights to discipline someone who calls in or is a no-show. Now, again, that is so it takes away those rights as an employer to address disciplinary issues, and can put it into the sticky situation of an employee filing, oh, I'm being retaliated against because I was sick for 3 days and called off. And if your employer, for instance, has a point system, some some companies do, where it's a no fault policy, where you show up late, you have to leave early with no notice, or you call off, you get points. And after a certain period of time, you get a verbal warning, you get the written warning, maybe a suspension, and then ultimately termination. Well, under ESTA, it's saying you cannot take those types of disciplinary steps, whether it's in your policy or a point system, if they're using their ESTA time. So that really handcuffs an employer to deal with those types of disruptions. Payout upon termination under the current language is not required. Leo, in fact, we'll see later, chimes in as well. Shift coverage. Employees must not be required to find a shift replacement. Now, some companies, I'll give it as an example, perhaps in the hospitality world, those companies or restaurants may require someone to tap a coworker to replace them for their shift. Under ESTA, if someone calls off, you can't require them to find their replacement. Here are some other updates under ESTA. Rehires. They must be able to retain their unused time, ESTA time, if they're rehired within 6 months. And if your company is bought out by another company, they still retain those particular rights to their ESTA time. Or say you transfer employees to another division within your corporation. If you have multiple companies under the same umbrella, common ownership still applies, whether you move them to another company, subsidiary, location, they still have that blanket coverage. And as I said, there's no fault attendance policies. You can't count their absences, tardies, leaving early for sickness under your point policy. Family coverage includes not just relatives, but equivalent to family. A family member includes a biological, adopted, or foster child, stepchild, legal ward, a child of a domestic partner, or a child to whom the employee stands in for as local parentis. It can be a biological parent, foster parent, step parent, adoptive parent, a legal guardian of someone, of an employee or an employee's spouse, or a domestic partner, or a person who stood in as local parentis when they were growing up. So you may have an employee who had an aunt who helped raise them, or one of your parents' best friends who they're considered local parentis. Very ambiguous. There's no way to really have checks and balances with that. It is basically on the honor system. It could be a person to whom the employee is legally married, or a domestic partner, a grandparent, a grandchild, a biological foster or adopted sibling. And any other, this is where it covers a blanket of any affinity. So whether they're related by blood or that they are like family, they're so close, that is considered, they could take an ESTA day to care for that particular individual. A doctor's note, typically in HR, we say, okay, if someone's off for 3 days, we ask for a doctor's note to just verify it, right? And up until now, that's been kind of our rule of thumb. Well, ESTA changes that, and particularly if there is a cost for that employee to get that doctor's note or that form filled out, which many times now there is $25, $30, $50, whatever that may mean, the employer is now bearing that burden to cover that cost in order to get what they're asking for, a doctor's note. What are some permissible uses of earned sick time? For the employee's own care, for a myriad of reasons here. For their family members' medical care, again, very similar reasons. And then also for domestic violence of themselves. And of course, it would then also cover one of their family members. Those are the three generalized buckets. And also, this is an extension for certain meetings at your child's school. So if it's related to their health or disability, or if the child was a victim of domestic violence or any assault on the child. And here, it's kind of hard to, how do you verify like a note for this, right? Or is it just a couple hours to have a meeting to cover an IEP meeting for your child's special needs under their schooling, things of that nature is what it is meant to cover. Or say there's a closure due to a public health emergency where um, maybe it's the child's school or daycare that has a public health emergency and they had to shut it down. The parent can then take an ESTA day for such an event like that. There's do's and don'ts of documentation. Now, remember what I talked about, that 3 days rule of thumb that we typically have in HR before we ask for a doctor's note to excuse them if they're going to be out longer. Well, under ESTA, you could still request that reasonable documentation, but really it's from the 4th day on, like an extra day, not to require documentation for absences of 3 days or less. How they came up with that, again, that's why the Senate and the House bills were presented. What is documentation? What is reasonable? If it's signed by a healthcare professional, and that can mean, well, who's a healthcare professional? It could be the nurse, the doctor, the midwife, an ER personnel, or any licensed healthcare provider. You must pay out any of the employees' out-of-pocket costs for this documentation. So the logistics of that would most likely be you would reimburse them via payroll or your expense system, getting verification of what that cost was, or arranging payment directly with the doctor. So you can see that administrative burden and the cost to cover all of that, and not to require documentation that explains the nature of the illness that the employee is claiming or any details of the violence, if that was the case. Employers may require employees to provide documentation in a timely manner. However, again, do not disclose those details or anything that you obtain on said note or form or document are, of course, as we know in HR, we keep that explicitly confidential, so that no one else sees that outside of HR, including the manager. Well, the questions that we get a lot, one of them is, well, what about my current PTO policy? That should satisfy ESTA, right? Possibly. If employees can use your PTO policy for the same reasons and under the same terms and conditions as permitted by ESTA, chances are, sure. But here's the thing. ESTA is so expansive, and PTO policies, you have your or vacation or sick buckets or personnel, they have very definitive rules. And they're typically more administratively feasible than what ESTA is overlaying. I have yet to see maybe one PTO policy from an employer that they just laid over ESTA over top and everything worked. In most cases, you're not going to want to have employees taking PTO time under the same conditions as ESTA. So consider this. Does your PTO accrue at an equal or faster rate than ESTA? Does the PTO policy have a waiting period of less than 90 days? Does the PTO policy require advance notice of at least 7 days off to take PTO? And does it roll over year to year? Many have caps that are set for rolling over, right? Or they don't, it's use it or lose it. So right there, even if you don't meet, if you meet all of these and even just one you don't meet, then your policy will not play nicely with ESTA. Many employees, some employees, you have policies at your company where you have to use, a certain amount of PTO in the smallest increments. Some it's a full day or a half a day. But do you allow employees to use PTO in the smallest amount of increments? If it's 1 hour or if it's less, your payroll system counts 0.25 work time. Can they take 0.25 PTO time? In many cases, it doesn't get that granular. Are all employees eligible for PTO, including part-time and temporary employees? And I would garner to say most employers, some may give PTO time to part-time sometimes, and you don't give it to your temporary employees, right? So right there, that won't work nicely with ESTA. And is PTO reinstated for rehires within 6 months of termination? Probably not, right? So already you can see, oh, this is problematic. We can't just use our PTO time. Under the PMLA Act, which Michigan is under now, it just says, hey, if you give at least this amount, just you have it covered in your vacation or PTO. Made it super simple, right? And so regarding the notice and record keeping, this is where the fun really begins, right? I don't mean to say fun in the fun way. Oh, we love documentation and administrative details, don't we? Employers must post a notice informing employees of their ESTA rights. And now Leo has a form on their website. It has to be written and provided to all employees by February 21st, and also to all new hires upon their hire. I'd say a rule of thumb, you get the poster, you make sure that's up, you provide that the policy to all employees on February 21st. This is what it is and how it works with our other time off policies. And then additionally, when you have your new hire packet, or whether if it's an onboarding system online through payroll, or if it's the old fashioned, here's your employment packet, make sure that that policy is also in there. And for added protection, it's always good to get a signature on that policy. It could be also, of course, should be added to your employee handbook. So you've got 3 touch points, 4 with the poster, to make sure they get all of that information. And you must retain these records for 3 years. Their hours worked, their time that they've earned, and if you don't, there will be fines. ESTA doesn't require reporting earned sick time on pay stubs, though, so you get a little bit of relief there. Now, for union employees, if you have a union employees at your company that are covered by a collective bargaining unit, you follow the terms of the CBA until it expires. However, if that's only if there's sick time benefits outlined in there. If there isn't, if it's silent, then ESTA will take effect on February 21st for employees covered by a CBA if they don't reference any sick time in there. However, any future union agreements, once those agreements come due for negotiations, that's when the ESTA Act has to be pulled in to make sure it's at least at minimum covering and complying with ESTA. Of course, with CBAs, it could always be richer. But even if a union contract provides sick leave benefits, they have to at least equate to be the equivalent of ESTA. Special situations. We talked about how sick time balances should port over to successor employers. Employees who are terminated and rehired within 6 months should have their previous earned sick time balances restored. Employees whose wages vary based on work must pay the sick time in an average hourly wage. So what's an example here? They maybe work a shift differential. During the daytime, it's X amount per hour. They pick up a third shift. Maybe they get 50 cents extra an hour, and a dollar more per hour. You have to average that all together to determine what their average hourly wage is in order to then pay their ESTA time. And wait, there's more. I'll explain in a moment here. Exempt employees are presumed to work 40 hours per week unless it's over 40. So that's at least a caveat here for exempt salary employees. So let's walk through some common questions that we've gotten before that you may be thinking yourself. How do you compute sick time leave for salary employees? Well, you can assume that it's based on 40 hours per week. However, if you have, if you know that employees, you say, no, ours is 45 or 50 hours per week that you must work, then use that number. But you should be able to base it on 40, unless you're mandating, hey, everyone has to work a 50-hour work week. That's what we do here. Do you need to show accrual of sick leave on employees' pay stubs? We already mentioned a couple slides ago, it doesn't require that, but you still need to track it. Now, whether that's in your payroll system or in a fraught with manual errors spreadsheet, you still need to track it, but you don't have to put it on the pay stubs. Can you front load the sick time leave? Well, we got clarification from Leo that says, well, because there's no limit on the amount an employee can accrue and carry over, it's really up to the employers to evaluate that the accruals, at least annually, check it annually, that those are balancing to the hours worked, and then how does it then what's the delta? What's left over to carry over any balance? So Leo says employers can recoup front loaded time. This is important because this was silent originally, that if someone were to leave and they took more ESTA time than they accrued, then it says you can take those wages back. However, under Michigan law, you really need to have all your ducks in a row. And it starts with the creation of this ESTA policy. If you already don't have it where the employee signs off on this, you cannot reduce their final paycheck to anything less than minimum wage, and you have to obtain a prior written voluntary agreement for the deduction. So what I do for my clients is I have this and the stock and standard language that is compliant within Michigan, that they say, hey, employee, just as a heads up, this is your ESTA time, but if you use more than you accrue and you leave the company, we are going to recoup it from your final check, and you understand this and acknowledge this and agree to this, sign here. So that has to be done in order to follow the letter of the law. Otherwise, the employee can come back and file suit and say, hey, this, my rights were violated. They didn't have this policy. So that's why you need that. Can we pay out the sick leave at the end of the year in lieu of carryover? Leo says, no, you cannot. Well, how does ESTA interact with FMLA? When you have 50 or more employees, you're subject to providing this, the Unpaid Family Medical Leave Act, right, up to 12 weeks. Well, it may run concurrently, but under the current interpretation of ESTA, if sick leave is being used, meaning ESTA time, then the ESTA notice and documentation requirements apply. So it really starts to conflict with FMLA. And what about short-term disability? Some companies who also offer paid short-term disability, and they're used to balancing it between the paid disability and the FMLA time, because the FMLA time is not paid time. It's just guaranteeing their job while they're out. You got ESTA overlaid on that. Can you see the confusion? Many disability plans have like a 1 week or maybe 2 weeks waiting time before they get their disability pay. And it's not at 100%. It's typically around the 60% of their wages. So how does ESTA play into that? And then how does the disability fall into line? And then FMLA, where does it fall in? So this is our complex HR world. how do you compute your number of employees if you have employees in several states? You need to count them. However, if you have employees in Ohio or Indiana, they count in the head count, meaning that threshold of one employee, or should say the 10 or under or the 10 or over. But the ones in Ohio, Indiana, they don't get ESTA rights, but you have to count them in the head count for qualifying for which bucket of ESTA time that you're in. So, and under ESTA, do independent contractors earn sick leave? Well, if they're properly classified as an independent contractor, they're not an employee then, right? So they don't have any benefits such as sick leave or health care. Here's the thing. I see so many companies really in the gray when they have these independent contractors. What is a properly classified independent contractor? That is a whole different webinar that would take a full hour to walk you through and train. But you have to make sure that they're not just someone on 1099 that you're paying. There's more rules and stipulations, and this is a lot of gray that I see. So take a look. If you do pay anyone on 1099, that could be gray, and I sincerely ask you to reach out for support to interpret that better, because you're going to find yourself with more than just ESTA in non-compliance if you have independent contractors that are not really independent contractors. How do you compute the wage rate for sick time if employees' wage rates vary based on their work performed, right? Well, as we talked about, it's the normal hourly wage means the average hourly wage of an employee. And get this, it's for the pay period immediately prior to the pay period in which the employee uses their ESTA paid time. But fringe benefits aren't included in that calculation. And so here it's ambiguously including overtime, two different rates of pay. How do you average that out? But at least it's to the week prior and not the entire year. But look at that administrative burden and all that math that has to be calculated to figure out what to pay them. Can you feel that tension of your payroll processors? Or maybe you're that payroll processor. Wow. Well, this is where the House bill and the Senate bill pending amendments comes into play, because I can almost guarantee you the folks who wrote ESTA, they're not HR practitioners, they're not payroll processors. We think down to the how are we going to execute this, and what's the administration? So lifting the fog of ambiguity here, we have two pending amendments that have been set forth. And so what we're going to do is we're going to walk through, now that you have this foundation of what the ESTA legislation is, these two amendments, we're going to overlay it on top of that to see how they compare. That will help eliminate or clarify or streamline some of these administrative burdens. So get ready. We talked about the benefit year being 1 year. So this is kind of comparing it to what the ESTA language is and if it's congruent or if they're recommending changes. The House bill and the Senate bill, in some areas, they're very similar or they're exactly alike. In other cases, you'll see that they're not congruent and couldn't be farther than being aligned. And you'll also see that the House bill seems to hit upon the most solutions to ease this administrative burden. And I should say the cost burden as well, right? There's the Senate bill is a little bit more employee friendly. It doesn't really address some things. There's only one check mark in the Senate bucket, the Senate bill bucket, that is more advantageous the way it's described than the House bill. So let's kind of dig in here, and I'll give some commentary where needed on each of these. So the benefit year is, under both of these amendments, it stays true. An employer can use any 12-month consecutive period that you like. This is where it changes a little bit. What is the definition of an employee? What about what we talked about, independent contractors and other classifications? Well, under the House bill, it clearly states that an eligible employee is someone who the employer is required to withhold pay for federal income tax, meaning someone on your payroll, right? That they're getting their taxes um, deducted properly. Typically, your 1099 employees, they are not getting those taxes deducted. So, by definition, they're saying independent contractors don't apply. It doesn't speak to this in the Senate bill. Again, going deeper into what the definition of an employee is, seasonal employees, part-time employees. A seasonal employee is typically on your payroll. They're not coming from a temp agency. It's a whole other bucket. Um, these employees would be exempt if employed by an employer for 25 weeks or less. So it gives a little bit of relief that, hey, if they're only working for part of the summer or during a winter break, like when college kids come back home and they work, there's summer jobs every year or during a Christmas break, they wouldn't qualify. So you don't have to track it. Under the Senate bill, they don't address that nuance. What about part-time employees? Someone who works less than 40 hours a week. And it exempts that classification if they work less than 24 hours per week during the immediately preceding benefit year. So basically, it's like looking back a year, or if they're expected to average less than 12 weeks in the current year. So basically, you have to monitor it and keep them under that 25-hour per week mark to make it super simple. But they don't cover that in the Senate bill. What about variable hour, out of state, rail and flight employees? Now, this is very specific here, but it must have been important because the House bill addresses it. Doesn't apply to everyone on this call, but it may. This exempts those employees whose primary work location is not in Michigan, which that's congruent with ESTA. It doesn't apply with variable hour employees. So that whole thing about the shift differential, they work the day shift, they pick up an evening shift. Um, it kind of takes the wind out of that average. But there's certain rail and flight deck employees that it specifically calls out here, and the Senate bill doesn't say anything about that. It helps to further define what a small business is, right? When we think of a small business, and many people on this call may be, um, it helps clarify and give a little bit more leeway here for employers that they don't offer sick time, and all of a sudden this cost and administrative burden is being put upon you, right? Well, under the House bill, they're stating that for the definition of a small business, employees are exempt if the employer has 50 or fewer employees. So you can see, you can breathe a little sigh of relief. But under the Senate bill that's proposed, it's businesses with 25 employees or fewer that need to provide 40 hours paid leave, 30 hours unpaid. So there's a little nuance here we see. We think it's a typo because, 72 hours was supposed to be the total under ESTA. So we really think it's supposed to be the 32 hours unpaid. So here's hoping that with these proposed changes that perhaps the House bill or any other tweaks made to it to improve it will be what comes out the other end on or before February 21st. It further defines what a healthcare provider is who can fill out the paperwork for ESTA. So I think administratively it's smoother. It changes it under the House bill to mirror the FMLA guidelines. So that's nicer, but it doesn't talk about it in the Senate bill. Retaliatory action. Remember, I said earlier that if an employee feels that their ESTA rights were violated, they can go straight and file a suit here. Well, here under the House bill, it removes that threat of action. It also removes that this nonsensical language that's deeper in ESTA that prevents sanctions against an employee who is a recipient of public benefits. So it gets really deep there. But this means that, hey, if you have to deal with someone who has attendance issues, you can certainly do so. But the Senate bill doesn't address that. What about combining paid time off? We talked about that here. It gives a little bit of relief. Specifies that ESTA may be combined with other paid leave, and it can include, but not limited to, paid vacation days, personal days, paid sick time that you already have, or any paid time off. So it really, in this case, mirrors the PMLA, right? Which we all, if we're already complying with that, it's just saying if you're already giving enough time in your collective time off buckets, you're good. So that is a sigh of relief. It doesn't say, let's see, under the Senate bill, it still has that problematic issue that it can be combined, but you have to stick with the same purposes and the same conditions. So that means, the documentation, the rollover provisions, and all of that, and the carryover. So it's not as favorable for the employee and administratively burdensome. Under the House bill, the carryover of benefits says that employers can limit the carryover of unused benefits to 72 hours from one benefit year to the other. And there's a further clarification version that employers are permitted but not required to allow an employee to carry over more than 72 hours if you so wanted to. So there's a little bit of relief there because currently there's no cap. And under the Senate bill, if the employer pays the employee out for unused sick time, they can limit the carryover to 144 hours, which, that's a lot of tracking and a lot of time and a lot of payout. So if you pay them out for what they've earned and haven't used, great. But you can limit it now to just 144 instead of unlimited. So you can still see the burden is there. Plus, if you don't pay them out for the unused sick time that they earned, you must allow them to have up to 288 hours of ESTA sick time carried over. So, wow. Front loading, the House bill says as an alternative to the accrual method, you can provide those 72 hours at the beginning of a benefit year. And the same language is under the Senate. So they're equal on that footing. But you can see how different they are, right? And I don't know how you're feeling, but I'm team House bill if this is going to go through. It gives a little bit more flexibility and breathing room. What about a year one calculation? Okay, let's specify that. If the benefit year begins before the House Bill 4002 is signed into law, then all time provided to an employee in the current benefit year can count towards the employer's compliance obligations. So not addressed in the Senate bill, but let's kind of like hone in on this a little bit more. If you start this benefit year before this House bill is signed into law, so say it's February 21st, but you start this process before then, all the time that you have already started counting counts, is what it's saying. It's not like you have to start over. If you started it, it started, and you can keep letting it roll. Calculation of sick time pay rate. This is a little bit of flexible breathing room too. This clarifies an employer is not required to include overtime, holiday pay, bonuses, commissions, supplemental pay, piece rate pay, tips, gratuities. None of that has to be figured into the calculation of the employee's normal hourly rate. Whew. Senate bill does not address that detail. Now let's talk about going back to the disciplinary actions here. Now, under ESTA, the way it's written, you can't take adverse disciplinary actions toward an employee for having poor attendance, even if it's a no-fault policy. It's considered falling under that retaliatory title, right? Well, here, the House bill is saying, well, let's talk about advance notice and disciplinary actions. An eligible employee, someone who's eligible for ESTA, shall comply with an employer's usual and customary notice, what the procedure is, the documentation requirements when they're using their sick time or leave. Basically, what you're doing now, if you're saying you have to give, notice as reasonable as possible, This is our usual and customary practice, our notice. You need to, maybe it's calling in a hotline or texting or calling the manager, whatever the process is, can apply and can continue. Now, this gets kind of interesting under the Senate bill. So I'm going to break this down a little bit too. An employer with mandated staffing ratios may require an employee to comply with the employer's leave policy. Otherwise, it's 7 days advance notice, or if the leave is foreseeable or as soon as practical, if it's unforeseeable. What is this staffing ratio, right? If that's something that you're not familiar with, it's probably because it's not in your industry. There could be mandated staffing ratios for industries such as healthcare, where you have to have so many nurses per patient ratio, education, teachers, how many, the student to teacher ratio, childcare providers, the children to caregiver ratio, or correctional facilities where they have to have so many um, of the correction officers at the prisons to the inmates, that type of a thing. So if you're not familiar with that, then it probably is not required for your industry. Let's dig into disciplinary actions for abuses. So, abusing time off, right? An employer may take disciplinary personnel action against an eligible employee, someone who is eligible for ESTA, if the employee fails to comply with the employer's usual and customary notice requirements. Every once in a while, you have an employee who just does not want to follow the process, turn in the documentation, and you can't get a hold of them. You don't know what's going on, and they pop up a week later, right? Ready to return to work. That's what they're saying. Under the Senate bill, it's not addressed. So it just basically is an employer's absence control policy shall not treat earned sick time taken under this act as an absence that could lead to or result to retaliatory personnel action. The whole um, the disciplinary steps that you would take. Now let's talk about this a little bit deeper about the no call, no show. It's a best practice that if it's 3 days and you haven't heard from an employee, they're considered a no call, no show. And it's then considered a voluntary resignation for a no call, no show. That's the current best practice in the standards that HR uses. So, how does that apply under ESTA? Under the House bill, for time of more than 3 consecutive days, an employer may require reasonable documentation or certification that meets the requirements under FMLA. So it's, typically those 3 days that they're needing to be off. You can say, hey, we need to now get some documentation. Specifies that an employer may take disciplinary personnel action against an employee if either of these following conditions is met. The employee is failing to comply with the employer's usual and customary notice, like we talked about, the notice, the procedure, how the documentation is requested when they're using ESTA time, and the eligible employee is absent from work for a period of 3 or more consecutive days without contacting the employer, that's acceptable at all. So if they pop up on the 4th or 5th day and say, oh, I'm very sorry, then it really is up to the employer to make a discretionary decision. If it's a hard and fast rule that, hey, we haven't heard from you for 3 days, you're terminated, or you may want to say, okay, something catastrophic happened, and you tried to reach their the emergency contact, and no one was replying, or whatever it may be, and they pop up 5 days later saying, oh, I'm able to come back to work, I just had a personal catastrophic issue that I was dealing with. You have to make your determination about that, whether to have them still be employed or not. I always say, there's always treat each case on an individual case by case basis. If it's using the best judgment that you can, black and white policies, they're black and white for a reason, but then there's also some extenuating circumstances that you may want to consider on a case by case basis, not to set a precedent for those, determining whether or not you would actually terminate someone. So that's just my HR advice. Talk about the Senate bill now with this no call, no show 3-day. It's not addressed beyond what's already in ESTA, so it's keeping that same language. Employers' absence control policy should not be treated toward that earned sick time. So it's basically saying how the lay of the land is under ESTA currently. You can't write them up, can't terminate them if they're using their sick time or applying for it. Now, how can this time be used? We have 10 minutes left here and a little bit more to cover. We may not have time for questions at the end, but we will be certain to follow up if you did enter any. How do you break down how much time they can use for ESTA? Under the House bill, while employers may limit the use to 1 hour, you're also allowed to choose a different policy that you'd like. You can say, oh, it's 4 hours or whatever you'd like. But put it in writing. You need to have this policy in writing. Under the Senate bill, it just says, well, 1 hour increments. House bill for concurrent leave. If that earned sick time also qualifies for FMLA or ADA or other state and federal laws, an employer may require that time to be taken concurrently. It's not addressed in the Senate bill. This is how we currently administer in HR time off under FMLA, ADA. They all dovetail concurrently because you don't want someone saying they're going to, they use all their ESTA time, 72 hours, and then their FMLA up to 12 weeks. So you can see how it just drags it all out. So concurrent is better. I do like that caveat there in the House bill. What's the documentation timeline? This also falls in line under the House bill with FMLA. We typically say, we're giving you this documentation by law. HR, the company, has to give it within 3 days of the person saying, I'm going to be off, whether that's a planned leave for surgery or having a baby, or oh my gosh, I'm having the baby today. He's coming early. So you have to give them that FMLA paperwork within 3 days by HR, but then you give them up to 15 days to get all the paperwork filled out by their doctor and everything like that. So that's reasonable, and it also aligns with FMLA. Doesn't speak to that in the Senate bill. Let's talk about when you bring back an employee who left the company or your company is bought out by another. Under the House bill, this is good news. An employer is not required to restore that previously accrued unused earned sick time if they pay it out for them at termination, which again is not required. And the same is true if your company gets bought out, then those employees say, hey, I want to come back to work for the company. You don't have to reinstate that time. The Senate bill is silent on that. Let's talk about this rebuttal presumption. And so here, the ESTA for this gets a little bit deeper. I want to kind of refer to some deeper notes here on this. What the heck does this mean, right? So ESTA contains a rebuttal presumption against the employer in any dispute that an employee uses ESTA, meaning that the onus is on the employer to prove that they're not guilty of retaliating against someone who didn't call in for 3 days or longer. But what it's saying here is that the House bill, as well as the Senate bill, it removes that onus on the employer. And it means that it puts the employee and the employer on equal footing, that they both have accountability with this. It's not just, oh, well, we terminated them because we didn't hear from them for several days. Well, you shouldn't have done that. It's saying that that presumption is taken off the table. Statute of limitations is not addressed under the House bill, but it is under the Senate. Check box for the Senate. That's the first one. They get one win over the House bill, but that's not enough. I would still go with the House bill. Private right of action. So this is also quite the relief. Under the House bill, the right to file a civil action is eliminated, as you can see also with the Senate. So that's a huge relief to that retaliation. Anything you do could be construed as retaliation against the employee during their ESTA time. Additional remedies. So this also softens it, the fines, the violations. It softens it a little bit. It retains the language in ESTA under the House bill that specifies employers who fail to provide earned sick time in violation are still subject to a $1,000 civil fine. Well, not unlike other fines that you would be subject to if you're not following the law. So there is an accountability and checks and balance there. But at least it's a limitation. And as for the Senate, this is where it gets a little bit more costly, not just the $1,000 fine, but you would be subject also to 8 times the employee's normal hourly rate for that time. Plus, you'd be paying them for their time plus 8 times the amount as your fine. So that's not so fun. So, what's the action plan here in our last 5 minutes? You need to create that new sick leave policy by February 21st. You really do. Know what you have here. It's overlaying it with your current leave policies and seeing, okay, if this is going to happen, we know what we're going to do. You don't publish it or share it with employees yet, but have a game plan. You also need to make sure that your HR team and your managers understand ESTA. It's the managers first that employees go to say, hey, I'm going to be off or I need to be off work. There has to be communication and coordination between if you have an HR team or an office manager and the employees' managers. They need to understand how to administer and stick to the policy and not violate ESTA. Thirdly, post those posters. Make sure that you're putting them in your onboarding hiring documentation. If you have a CBA, prep up for that. Review your current front-loading policies and see how they would align or dovetail with ESTA or if they don't. And finally, review and confirm that your payroll vendor and record keeping systems are able to handle ESTA compliance. Payroll companies should be able to add this code and do an accrual. They do it for time off like PTO. They should be able to do it for this and set those parameters. Otherwise, you're left to work on spreadsheets, which, as you know, can have manual human error. It's going to happen. So we are at time here in our last 2.5 minutes or so. And I know we do have some other updates to go over. So we'll refer back to the questions, as I said, and do some additional follow-ups. We also wanted to share that today's session is eligible for SHRM and HRCI recertification credits. So you will be receiving those via email separately, so you can log those credits should you wish, if you need them. And then also, if you're interested in knowing, is my organization compliant? What are my time off policies? How is this ESTA going to work? Or just to see overall, how compliant are you with HR compliance and state and federal regulations? The first step is to do an assessment, which Rehmann is happy to assist you with. So thank you, everyone. It's been a pleasure, as much as it can be, talking about ESTA. It's exciting, and we're going to help you stay on top of this, stay ahead of the curve, and be there to support you through this. We're in this ESTA together. I'd like to turn it back over to the team.
Thank you so much, Elizabeth. That was an amazing overview, and Rehmann for offering this opportunity for our members to learn more about this. We know this is a very urgent issue. If I haven't met you already, my name is Haley Bennett, and I'm the Director of Government Relations for the Northern Michigan Chamber Alliance. And this has been our top policy priority issue for months now, and we know that this is extremely urgent. So for more information, we'll be posting this recording on all of our social media channels, as well as our website, nmchamberalliance.com. And if you're not already following our page on LinkedIn, please do. That's where we share the most up-to-date news as it's happening right now. A great question that came up is, what's next? I'm sure you're all thinking that after this amazing overview of the difference between these two bills. And so right now, the time is perfect because we need all of you to act. This will come to a vote tomorrow. So the House will be taking this vote on the floor, House Bill 4002. So we need all of you to make sure you're contacting your representatives and letting them know how this will impact your business. But it's equally as important to also reach out to your senators, because if this does pass the House, it will still need the approval of the Senate to ultimately make it to the governor's desk. So please reach out to both your state House representative, your state senator, as well as the governor's office. And if you can share specific examples of how this will impact your business, that would be most helpful. So we look forward to continuing to serve you and making you aware of these changes as they're rapidly coming. Stay tuned for more and enjoy the rest of your day.